Hello, I'm Stephen Gold, and I wrote The Return of Breaking Law, which you should be reading. Please! Are you aged between 16 and 18 and wanting to enter into a marriage or civil partnership? You silly billies. Oops, pardon. Well, you can do it with parental consent or the permission of the court. Until, that is, the 27th of February 2023. On that date, a new act comes into force which will ban a marriage or civil partnership if you're under 18. The main reason for the change is to make it more difficult for forced marriages to take place. Now, what do you call a judge in a court or a tribunal? Don't you dare be rude. If it was a district judge in a civil or a magistrate's court, it was sir or madam, and similarly a employment judge or a first-tier tribunal judge. But now an edict has been issued that these judges should be called judge. How did they think of that? I was once called my lord, but I didn't object, and that was in a greasy spoon. And another edict has commanded that if it's a traffic commissioner you're appearing before, it's an unlikely event, but you never know, then you should call them sir or madam, and don't on the way out ask, "Any more fares, please?" Are you making a financial application, that's maintenance, property transfer, lump sum, pension share, that sort of thing, in a divorce or other matrimonial case? If a lawyer's making an application on behalf of a client, they must now do so online, and should instead they do it by post after the end of this month, February, and the application will be bounced back. But whether it's a lawyer making the application or you making an application in person, you will now be invited online to say whether or not you regard the application as urgent. And if you do, you might well achieve a queue jump. But it needs to be a real urgency situation, and the reasons given will have to be pretty powerful. Say a really dire financial predicament, that could well be sufficient. I recently excited you about the collective claim against MasterCard, where you could stand to receive compensation of anything in the region of £300 plus without your arms leaving your body. MasterCard is now seeking to exclude from consideration any transaction which took place in the UK before the 20th of June 1997, because they say, well, it's too late for such transactions to be taken into account. Well, that's an issue that is going to have to be decided. Now, although to be considered for compensation, you don't actually have to do anything, there is an exception, according to the claims website recently announced, where you were living abroad on 6th of September 2016, and that in that event, if you want to opt in to a claim, you've got to do something by the 2nd of March 2023. If you go to the website, you'll find out exactly what you've got to do, and here is the website address. If you're selling your property, you'll have to answer a questionnaire, millions of questions, which will go to the buyer before they commit themselves by exchanging contracts. Are there any neighbour disputes? Does the central heating work efficiently? And if you give a false answer, which is relied on by the buyer, and they suffer some loss as a result, whether it's innocently given or fraudulently given, you could end up paying the buyer damages. These days, you're likely to be asked about Japanese knotweed. Well, in a case just decided by the Central London County Court, an accountant who gave a false answer to a Japanese knotweed question has just been ordered to pay the buyer damages of £32,000 plus costs, likely to be in the region of £95,000. Well, if you want to try and avoid having to say something nasty about the property to your buyer, you can always try this reply to an awkward question. The buyer should rely on their own inspection and expert advice. I always used to ask sellers, is the property haunted? Used to get some pretty interesting responses to that. Incidentally, if you want to learn much more about Japanese knotweed claims, there's plenty on it in my book, The Return of Breaking Law. I expect you've heard about the Tate Modern case just decided by the Supreme Court. They're a group of neighbours in a luxury block of flats adjacent to the Tate were fed up with being peered at from the top floor of one of Tate's buildings, where there was a viewing gallery, and it was estimated that at least 500,000 visitors were at it, peering a year, while the Supreme Court ruled by majority that amounted to a nuisance. What now has to be decided is the remedy. Do the residents get an injunction, damages, or something else, or a combination of remedies? We have to wait and see. What the majority decision is likely to have done, though, is to have shifted the way in favour of complainants that courts deal with claims based in nuisance on visual interference in the future. Generally, though, you haven't got a claim simply because the building erected on land next door is an eyesore for you, or next door can see you undressing in your bedroom, although for a prurient there would be other ways of stopping this, probably through the police, or because next door's painted their grass yellow with blue spots. But the Supreme Court significantly did not rule out the possibility in the future of a successful claim on the basis that the construction or design of a building was so unusual and so far from anything that could actually have been expected that it does or did amount to a nuisance. Interesting developments in litigation in this field for the future. If you're a lawyer, pretending to be a lawyer, or training to be a lawyer, what's about to follow is likely to bore you rigid, so do feel free to pop out for a more teaser or something stronger. The Court Funds Office special account rate has been increased to 3.5% as from the 16th of January. This rate is used to calculate interest on special losses in claims for personal injury. You get 1/2 of a rate. Expect a further hike soon as a result of the Bank of England base rate having been increased by 0.5% as from the 2nd of February. The civil procedure rules are being amended as from the 6th of April 2023. The most riveting change, if you're susceptible to being riveted by anything in the civil procedure rules, relates to QOX claims. That's qualified one-way cost-shifting claims. Where the claimant is to receive damages and interest, whether by court order, court judgment, or by agreement between the parties, then the defendant will be able to set off any cost orders made in favour of defendant against not only those damages and interest, but against any cost orders made in favour of the claimant against the defendant. Got it? Not retrospective. The Court of Appeal has now spoken on how courts should assess damages where you've got a mixture of claims, where there's a claim for a whiplash injury, which is caught by the tariff, and there's a claim for another injury in respect of the same accident, which is outside the scope of the tariff. The Court of Appeal has ruled that the assessing court should, first of all, fix a sum for the whiplash according to a tariff, and then fix a sum for any additional pain and suffering and loss of amenity arising out of the non-tariff injury on common law principles. Then sit back, look at both figures, make an adjustment for any overcompensation, and then proceed accordingly.